Bom dia a todos, muito obrigado pela presença nesse último dia do nosso seminário internacional do IBRAC. Obviamente, mais uma vez, agradecendo a organização, o Márcio, a Leonor, o Francisco, que organizou esse painel aqui também com tanto esforço, e aos nossos convidados estrangeiros que vão aqui nos brindar com com suas experiências e os seus ensinamentos a respeito da discussão de temas de antitrust que rodam o mundo, né? São alguns semelhantes aos que a gente discute no Brasil, mas certamente eles têm muito a nos contar sobre aspectos práticos das discussões, né? Então, só para explicar a vocês como nós faremos o painel, nós dividimos as perguntas, nós preparamos as perguntas para os panelistas, os speakers, em 6 temas diferentes, né? Então, nós vamos dividir as nossas perguntas por temas e vamos realizar as perguntas ou passar as perguntas para cada um dos panelistas de acordo com os temas como foi combinado. Nós esperamos ter algum tempo ao final das perguntas para abrir o debate, mas, obviamente, isso vai depender muito do controle do tempo, que ficará a cargo do Dr. Francisco, que será o nosso, I don't know how to translate this, nosso bedel. To translate in Portuguese, it's bedel. So, muito obrigado a todos. Nós não faremos, os panelistas aqui dispensam apresentações, todos já estiveram nos nossos painéis, todos já nos brindaram com suas sabedorias. Então, acho que a gente pode partir direto para as perguntas e passo aqui a palavra ao Francisco para começarmos aqui os debates. Muito obrigado.
Obrigado, Lauro. Muito bom dia a todos. Um breve cumprimento e agradecimento ao Márcio e à Leonor pela primorosa organização do seminário. Indo direto para o início das nossas perguntas, nossa primeira sessão é sobre Key Developments no mundo. E nós começamos com uma pergunta para o Christian, do FTC. O FTC concluiu recentemente uma série de audiências públicas com foco em consumidor e concorrência, especialmente questões relacionadas a novas tecnologias e economia digital. E muitas dessas questões, por sinal, elas foram tratadas no nosso seminário dos últimos dias. Christian, para dar início aqui à nossa sessão de perguntas e respostas, você poderia nos contar um pouco sobre essas audiências públicas que foram conduzidas pela FTC e os seus principais resultados?
Muito obrigado e bom dia a todos. I think by now you will not be surprised that I will start with our usual FTC disclaimer that the views expressed are my own and they do not necessarily reflect those of the Federal Trade Commission or any of its individual commissioners. Thank you so much for this question, which is a very important development that I wanted to touch upon that took place in the United States in 2018-19, which is the series of FTC hearings focusing on competition and consumer protection issues in the 21st century. This was a major policy initiative by FTC Chairman Joe Simons that started in 2018, and over a series of 14 hearings that spanned 23 days, the FTC held a number of hearings focusing on individual topics that Francisco mentioned as well. We actually covered over the last couple of days here as part of the IBRAC program. So we covered, for example, vertical mergers that we had a discussion here as part of this Congress. We talked, for example, about algorithms, some of the interface issues when it comes to competition, consumer protection, and privacy, including data and big data issues. But again, other topics that we also covered here, for example, nascent competition and potential competition, and the acquisition of nascent and potential competitors. What was the key objective when it comes to these hearings? And that was, as part of a self-reflection, self-assessment exercise that agencies and competition agencies regularly have to do, and constantly, if possible, have to do, the FTC had to see and realize that there have been so many changes that mostly related to digital issues, for example, in the technological world, that we actually have to step back for a bit and see if our tools, the antitrust tools we have, serve us as good as effectively as they can, or perhaps there is some kind of need to adjust the tools, perhaps to adjust our economic thinking in that regard, and see if there is anything in that regard that the agency can and should be doing going forward. This particular series of hearings, again, focused on these new digital and other type of technological issues, but also very importantly, as part of our self-reflection, self-assessment exercise, it also followed the format of what we previously had, for example, in 1995, so-called Pitofsky hearings under the chairmanship of former FTC Chair Bob Pitofsky. And in 2008 as well, the FTC held a series of similar hearings, the FTC at 100. When it comes to kind of like what are the key potential outputs or what do we expect from the hearings, so we had a number of discussions, over 100 panels, several hundred participants from academia, practitioners, economists, agency officials, and then we received also over 3,000 public comments that the FTC has reviewed and analyzed as part of this exercise. And we are currently working on a number of outputs that I will highly recommend for you to look at. It will probably come out over the next year. But first and foremost, and very importantly, one of the key outputs will be a guidance document on how the antitrust laws might apply to conduct by technology companies and technology platforms. And this particular guidance document will address a number of issues, including market definition, market power, and a number of other important issues that if you look at the setup of the hearings, the questions that we circulated in advance of the hearings, they will provide as a good guidance as well. Very importantly, the FTC is also working on a guidance document on vertical mergers that will be very similar in format to what the FTC had in 2006, which was a commentary to the horizontal merger guidelines back then. And this guidance document, again, focusing on vertical mergers, will address a number of important issues that have come up recently in enforcement and policy. Very importantly, a third important outcome will be an addendum to this 2006 horizontal merger guidelines commentary, which will primarily focus on two key issues. One is how the agencies look at acquisitions of nascent competitors, and the other one is how agency staff takes into account non-price factors when it comes to merger analysis. And in addition to these three key, very important outputs, we will also work on an analysis of on the consumer welfare standard and potential alternatives. In addition to that, a very important topic is merger retrospectives, on which we also held a hearing as part of the FTC hearings. I would also like to congratulate CAGI, as I saw a week or so ago. CAGI also published its very first retrospective study in the Sagia-Pedigo matter. The FTC has been doing merger retrospectives now for a number of decades in a number of industries. And as part of this particular exercise, we're also putting out a protocol for merger retrospective programs. And last, there's also a staff report that we are working on and we are about to release on international competition issues. This is kind of like what the main outputs will be when it comes to the hearings. And in addition to that, I think I mentioned that as part of my remarks 2 days ago as well, that the FTC has been focusing on setting up new technology enforcement division as well. So we're looking at these issues in that regard as well. Thank you so much.
Thank you.
Okay. Thank you, Chris. It's great to hear from you, or this, let's say, this key developments in the United States in which FTC is jumping in. But moving to Benjamin Sirota, our, let's say, litigator. But let's talk about, we know that, sorry, I'm speaking in English, tem que falar em português, desculpem. Nós já sabemos que o processo eleitoral nos Estados Unidos está avançando de uma forma ou outra, às vezes em trancos e barrancos, e a gente sabe que antitrust é um dos itens de discussão política nas campanhas. Então, nós gostaríamos de ouvir de você, nessas discussões eleitorais, quais são os temas que estão surgindo? Quais são as ideias ou propostas que os candidatos, e no caso especialmente o Partido Democrata, né, tem desenvolvido discussões a respeito? Por favor. Obrigado.
Thank you very much. Well, I think the first thing I would say is to emphasize, I've never in my career seen anything like what's going on in the United States, which is people are really actively talking about antitrust. And when I say people, I mean not just people in this antitrust world we inhabit, but ordinary people seem to care about this. My wife and my friends actually are interested in what I do for perhaps the first time in my career. It's incredibly exciting. I think it's a testament to how much notions of the big technology companies, privacy, some of these other issues that are sort of ancillary to antitrust have been interwoven with antitrust, and they've seeped into the political discussion as well. So let me outline briefly some of what's being discussed. There are different proposals for legislative action, actually bills that various Democratic candidates have proposed. And then there are proposals for how to beef up enforcement within the current system we have. Some of the legislative proposals include a bill to make monopolization enforcement stronger. This is actually a bill that has been proposed, although I doubt it's going to get passed, at least under how Congress is currently constituted. This would allow the agencies to obtain civil fines in connection with a monopolization case, up to 15% of a company's revenue. So that would obviously be a big change from how monopolization enforcement works currently. Elizabeth Warren has proposed a legislative effort that would essentially create a bright line rule such that platforms could not also offer products on the platforms that they operate. And if the platform is big enough, it would be a complete prohibition. And if the platform is a little bit under that level, there would be a series of prohibitions, but not an absolute one in terms of offering services. And there's a variety of other things being discussed as well. On the enforcement end, I think all of the Democratic candidates believe in what they say is more aggressive enforcement. And what does that mean? Many of them are talking about blocking mergers and unwinding consummated mergers, and they're doing it with specificity to the mergers. They're not just saying, we think as a general rule, consummated mergers should be looked at. They're actually identifying specific deals that in their view should be unwound. And that is pretty uncustomary, I think, in United States discourse to have people sort of ex ante saying these are the deals that need to go away. And the final thing I'll mention in terms of the political discussion in the US that's interesting is there's a discussion about who actually sits in senior leadership in the agencies. I think traditionally, with some exceptions, it's been people from the antitrust world, antitrust practitioners, lawyers. And there's a discussion now going on amongst some of the candidates about whether we should be pulling in academics, economists, people who look a little different than the people traditionally who've run the FTC and DOJ. So a lot going on. Obviously, everything turns on who wins the White House, but it's going to be interesting to see how things unfold.
Thank you.
Thank you, Ben. Moving a little bit to Europe, Rick, desculpe. Obrigado, Ben. Indo agora para a Europa, Rick, você poderia nos dar um panorama geral dos principais desenvolvimentos recentes na União Europeia?
Sure. Yeah, I will limit myself to developments in the area of private enforcement because that's what I'm specialized in, and I don't know about all the recent developments in the EU. But one development which is worth mentioning also in relation to yesterday's panel on disclosure is that the European Commission recently closed a public consultation on a draft communication from the Commission on the protection of confidential information for the private enforcement of EU competition law by national courts. The draft version is available in all the languages of the EU member states, so also in English and even in Portuguese, for those who are interested in it. And the Commission briefly explains the possible measures to protect confidentiality of information and documents that have been submitted to the European Commission. And I think it's worth taking notice of it, as it briefly explains how to create a confidentiality ring, how documents can be redacted so that they can still be submitted or become disclosable to other parties, how hearings can be ordered in camera, and how appointments or experts can be appointed for drafting summaries of confidential information and confidential documents, or how they can aggregate the information so that it can become disclosable to other parties. So that's one development from an EU perspective. Then focusing a little more to the Netherlands, there is a lot going on in the Netherlands in the area of private enforcement. We have many cases that have been brought before the civil courts. Just to mention a few, one of the first major private enforcement cases was the air cargo follow-on damages case. And we recently celebrated the 10th anniversary. And it's even better from a defendant's point of view that we're still at the preliminary phase. So we're not even halfway. Another one is the gas-insulated switchgear cases. And so far, those two are the only two proceedings that have resulted in a specific damages amount that was awarded by the court to the claimants. Although those two cases are still under appeal, so it remains to be seen whether those damages will be upheld by the Court of Appeal. But it was, of course, a landmark case, so to speak. And we also have trucks. Trucks is probably the biggest private enforcement case we are dealing with in the Netherlands right now. And I can tell you, not only in the Netherlands, but also in Germany, in the UK, and also several other EU countries. Also the countries that are less popular for bringing private enforcement cases. So that's perhaps the beginning of a new era. If you look to the trucks cases in the Netherlands, then you can see that the assignment model is frequently being used by the claimants. So thousands of individual claims have been assigned and transferred to a commercial claim vehicle. And that vehicle acts in its own name and on its own behalf. And most of the main cases are such collections of individual claims, and they need to be distinguished from a class action or collective redress mechanisms. It's just a bundle of individual claims. And all of these claim vehicles first want to obtain declaratory or a declaratory judgment saying that the OEMs have acted unlawful and that the OEMs are liable for the damage suffered as a result from that conduct. And such declaratory judgment can be used as a stepping stone either for the start of settlement negotiations or for follow-up proceedings on the determination of damages. And the threshold or to get to that second phase is very low, because you only need to establish that it is plausible that the claimant possibly suffered harm. So that threshold is fairly easy to reach. And what the claim vehicles did is they argued that due to the fact that they are only seeking declaratory relief in the first phase of the proceedings, that they only need to state, and simply state, that the assigners purchased, leased or used trucks from the addressees of the Commission decision during the infringement period. And the reason why is that the Court of Justice of the EU previously ruled that claims for damages can be directly based on the European cartel prohibition. And in this case, there is a settlement decision, so it's a final decision. So they think we don't need to state more or to substantiate our claim more than by simply stating that we've purchased trucks. And this approach taken by the claimants has raised some interesting questions, and particularly with respect to the obligation to furnish facts as to whether a different threshold should apply to those commercial claim vehicles. And the Amsterdam District Court brought some clarity in this respect in its judgment of 15 May of this year. It first assessed the statutory elements with regard to the writ of summons. And it ruled that the writ of summons must clearly indicate what is being claimed from the defendant and what the grounds are for the claim. So nothing new, of course. And it must be sufficiently clear to the defendant what is required of him so that he can properly defend himself against the claims. But the claimant, according to the court, must also assert all of the facts necessary to grant the relief it requests. And this entails that upon the commencement of the proceedings, the summons must assert all of the factual elements that the law requires to grant the claim. And a very important element in the decision of the court is that by law, the litigation vehicles' claims are nothing more than the collected claims of each of the underlying purchasers of the trucks. So that means that the claimants had to do more than they had already done. It was not sufficient just to simply state that they had purchased trucks during the infringement period, full stop. They had to substantiate their claims further, and they had to do it for each individual assigner, and they must assert and substantiate in any case, as it stands now, sufficient facts in order to be able to assess for each of the owners, renters or lessees or users of the trucks whether the parties incurred harm as a result of the cartel during the infringement period or the post-infringement period, in order to establish that required plausibility of the possibility of harm. So at least we have got some clarity, and it might, let's say, disincentivize the commercial claim vehicles to bundle too many claims at one and the same time, because this is a very high burden of proof in order to bring a claim in that way. Thank you.
Thank you. Voltando aos Estados Unidos, Roberto, na sua opinião, quais são outros destaques, vamos dizer assim, que os Estados Unidos estão discutindo em matéria de antitrust? O que mais você gostaria de destacar nessas discussões atuais?
Thank you. Good morning. Over the last 20 or so years, there's been a lot of discussion in the U.S. about the proper role of antitrust in addressing issues involving intellectual property. The history of it would take a very restrictive view of the use of IP in what appear to be restrictive ways, going back to the era of the so-called 9 no-nos, when the DOJ announced a policy, a licensing policy that was extremely restrictive and left little room for patent owners and other IP owners to license their IP rights in a way that was restrictive at all. But in more recent years, commentators, the agencies, the courts have taken a very different view at those issues, and there's been a bit of a debate more recently as the pendulum may be swinging back the other way. So I'll point to 3 developments that are current regarding IP and antitrust in the U.S. The first is the FTC's Qualcomm case. The Qualcomm activity in the U.S. is part of the worldwide attack on Qualcomm's licensing practices, partly focused on its position as a chip manufacturer, partly focused on its role as a licensor, and certainly involving the way the two interrelate. The FTC filed a complaint in U.S. District Court in Northern California against Qualcomm, alleging that various of its policies violated Section 2 of the Sherman Act. The FTC complaint sought injunctive relief, and that meant that it was tried to the court as opposed to a jury, to Judge Lucy Coe, who happens also to have been the same district judge who was responsible for the the well-known Apple-Samsung patent litigation, which was an enormous case, resulting initially in a $1 billion judgment that went to the US Supreme Court. Judge Koh's decision determined that Qualcomm was liable for violating Section 2, but the case and the decision has generated a good deal of controversy. First, the Department of Justice took a position contrary to that taken by the FTC. The DOJ actually submitted a statement in the case commenting on aspects of the relief that might be available, and the DOJ and various private parties have weighed in the appellate court in amicus briefs questioning Judge Koh's decision. Also, one of the members of the FTC, Commissioner Wilson, has publicly questioned the case. So it's a very interesting situation for the political dynamic of what's going on and enormously important substantively. So that's a case to watch as the appeal moves forward in the U.S. Court of Appeals for the Ninth Circuit. The second development I would point to involves the broader activities of the Department of Justice under Assistant Attorney General Del Rahim. During the Obama administration, there was a very clear stance that was taken by the administration regarding patents and antitrust. It was, in my estimation, very strongly anti-patent owner and very strongly pro-implementer. Under Assistant Attorney General Del Rahim, there's been a pretty dramatic shift in the way the division looks at patent issues, and the focus being on standard essential patents. There has been for many years a broad consensus regarding the role of standard essential patents and the antitrust issues that can arise. There has been a consensus that patent holdup is real, it happens, and that it's quite a serious problem with antitrust implications. Assistant Attorney General Del Rahim has called much of this into question. He's taken the stance that patent holdup may not even be a thing, it may not exist, and that whether it does or doesn't patent holdout, that is, a refusal by implementers to license on reasonable terms, is at least as serious a problem. This dialogue is very healthy in terms of calling into question some of the orthodoxy that has prevailed in the past, and it's also something to watch as we see how this develops. One of the key points being raised by Assistant Attorney General Del Rahim, and he's not the first or the only, is whether some of the issues that are identified with the alleged misuse of standard essential patents are antitrust issues at all. He's taken the position that these are contract law questions and should be dealt with outside the domain of antitrust entirely. It'll be interesting as things move forward to see how that debate continues to develop. The third thing I would identify involves the questions associated with large-scale patent aggregation and patent enforcement by non-practicing entities. Over the last 10 years, there's been a great deal of discussion about what happens with patent assertion entities as they enforce their patents. Under US patent law, patents are freely assignable, and it's very common for companies who don't practice any particular technology to acquire patents and enforce them. There are many stories of abusive assertion of patents, and the public imagination has been captured by this dialogue about abusive patent assertion. Well, certainly many of those stories are true, but there's a broader question that involves patent assertion by these non-practicing entities that is not abusive. Regardless, In recent years, there have been some monopolization claims made against large-scale patent owners. In a number of cases where a patent assertion entity has sued for infringement, counterclaims have been made, asserting that the plaintiff, the patent owner, the patent aggregator, has violated Section 2 in its practices. Typically, what the claims involve is an allegation that simply by virtue of its ownership of a large number of patents, the patent owner has acquired market power. Now, this argument is very different from what we usually see when markets are analyzed. Typically, and this is true of the academic work and the legal work involving patent pools and the like, it's simply not enough to say that a patent owner owns a lot of patents. We must look, as we would in any other context, at proper market definition. Are substitutes involved? Are the patents mere complements or are they unrelated? But the theory in some of these cases is that that's not necessary, and that merely by owning a large number of patents, the patent owner acquires power. The theory goes on that by virtue of owning this large number of patents, the patent owner somehow acquires the ability to coerce unjustified royalties, super competitive royalties. These issues haven't been tested on the merits to a great degree. In a case that I was involved in on the defense side, there were two iterations of the claim that were made by a large American bank. In the first case, the claims were dismissed at the outset. The court said there isn't a basis, you haven't articulated a proper market, and your claim appears to be based on the mere assertion of patents, and that's protected by the First Amendment to the US Constitution. The same bank filed a second claim. The case was litigated extensively, but at the end of the discovery process, the court granted summary judgment in favor of the defendants, my clients, on the basis that it was the second time around and they didn't get another chance, and that because their case was based on assertion, it was barred by the Norr-Pennington Doctrine, which implements the First Amendment. That case was appealed, and the judgment was affirmed on the ground that it was the second time around, they don't get a second bite at the apple. It's still pending on petition for rehearing and possible attempt to achieve US Supreme Court review. We'll see what happens. But, my case aside, there's a brand new case that's been filed in the last 2 weeks by Intel. And Intel has sued a company known as Fortress, making claims very similar to those that were made in the case that I litigated and in several others where counterclaims were made. This case is very new. The time for a response by the patent owner hasn't arrived. But the filing of the Intel case shows that these issues probably haven't died yet, notwithstanding the fact that the accused infringers haven't succeeded in achieving any substantial victories or in altering the antitrust analysis that would normally be applied. It looks like at least Intel has an interest in trying to keep those theories alive.
Obrigado, Robert. Passando, então, com essas 4 perguntas, concluímos nossa fase inicial dos Key Developments e a gente passa para uma discussão sobre temas verticais. Nesse contexto, a gente começaria perguntando para o Daniel O'Brien, da Compass Lexicon. O próprio Christian já mencionou, né, que estão sendo estudados guidelines para fusões verticais, operações verticais. Daniel, na sua visão, seria possível dizer que já atingimos um nível suficiente de compreensão sobre fusões verticais ou complementares a ponto de termos guidelines efetivos?
Yeah, so I generally think guidelines are a good idea if they can be written to provide useful guidance. The business community needs to understand what they're facing. with respect to antitrust concerns. My fear, based on the types of analysis that I see, is that guidelines in the vertical area might codify bad or sufficiently incomplete reasoning that it leads to problems down the road. So let me explain this in the context of an example involving the VGUPI, which we didn't really talk about in our session yesterday, so I'll say a little bit about it today. It's a tool that's been proposed for analyzing input foreclosure effects in vertical mergers, like those addressed in the AT&T Time Warner merger, although a bargaining analysis was used there, but it's similar. So I think it would be a bad idea to write guidelines that explicitly encourage the use of the VGUPI in vertical merger analysis. Okay, and I'll tell you why. So the VGUPI identifies upward pricing pressure from a vertical merger due to partial input foreclosure. And this has to be balanced against downward pricing pressure from EDM effects. Okay, so the idea is, AT&T, Time Warner might raise price to unintegrated rivals that compete with AT&T in order to shift customers to AT&T. They told a bargaining story in that case, which was a little bit different, but there's similarities. So there are two issues with the VGUPI. You have upward and downward pressures, right? So the first question is, how do you balance these effects? Well, taking some kind of average is insufficient. When these effects go through the washing machine that sort of fully evaluates equilibrium effects, that takes into account the interaction of the downward pressure from EDM and the upward pressure from foreclosure, the answer can be quite different than simply taking an average of these effects. Okay, so the only way to really properly calculate net effects is to build a more complete model that accounts for these effects and the interaction of these effects. I should say that the problem of using this price pressure style analysis is not as severe in the horizontal context because the effects of concern tend to be reinforcing. But here you have an upward effect and a downward effect. They're not reinforcing, and how they interact is very complicated. So what I'm suggesting is that the VGUPI, although that is in some ways more sophisticated than the analysis we tend to use in vertical merger analysis, it's not sophisticated enough, okay, to weigh these effects. And it very often misses the mark when you do a more careful, detailed analysis that reflects how these pressures actually interact. So the second issue with the VGUPI, continuing with that, is that it uses data or assumptions on margins and diversion ratios. And what I see happening with VGUPI analysis in cases that I see where it's used is I see people committing the same kinds of error that we saw for many, many years in the use of critical loss analysis. Consultants or governments making arguments about vertical effects might calculate VGUPIs from margins and diversion ratios, find net upward pricing pressure from a merger, but ignore that the margins that they're using are actually inconsistent with pre-merger optimizing behavior. This was the big problem with critical loss analysis, where essentially arguments were being made that margins were above the monopoly level, therefore it wouldn't pay to increase price further. With VGUPIs, the same kind of issue can arise. What I see is, if you have very small margins upstream and large margins downstream, if you apply a VGUPI, there's a good chance that you're going to find large net upward pricing pressure because the EDM effect is small and the upward pricing pressure is big. But if you think about why that upstream margin is small to begin with, the only logical explanation in a rigorous economic model is that the upstream firm actually faces lots of competition. So the conclusion that foreclosure is an outcome in that kind of case could be completely wrong. You have to check whether or not your margins are consistent with the economic model that you're using to motivate that analysis. So this example that I focused on with a VGUPI just kind of scratches the surface of the complications that arise in trying to incorporate analytical ideas into vertical merger guidelines. Another major complication has to do with complex contracting, contracts between upstream and downstream firms that are more complicated than simple per unit prices. That raises a lot of complications that have really been known about for decades, but really haven't very much entered the debate in antitrust applications, where we tend to rely on frameworks that assume per unit prices. I want to emphasize that I'm not saying that analytical approaches to studying vertical mergers is a bad idea at all. I'm saying quite to the contrary. You have to be very careful what framework you use to analyze these mergers, and that the framework that you're using fits the facts. That's really important. What I am saying is that certain specific analyses that are being used to analyze vertical mergers, while more sophisticated than what we've used in the past, are often not sophisticated enough, and the models in this area are very, very sensitive. So you have to be very cautious in the kinds of analytical constructs that you incorporate into guidelines. If I were sure that those writing the guidelines would do a good job reflecting what is known about all the complications that arise in the economics of vertical relationships, I would support the idea more than I do. But I'm a little afraid that there are important factors that haven't really entered the antitrust discourse, but which have been known for quite some time in the theoretical economic literature, that those factors are not going to be properly accounted for in guidelines. And I hope I'm wrong about that when the guidelines come out, if that's where we end up. The guidelines have to be written in a way, there's a lot we don't know as well, even at the theoretical level, with respect to vertical relationships. And certainly at the empirical level, there's not a lot of empirical work that's rigorous that studies this. So the guidelines would need to be written weakly enough to accommodate further development in our understanding of the economics of vertical relationships. Yeah.
Obrigado. Voltando à FTC, no mesmo tema, como é que você vê a evolução dessa metodologia de análises verticais? Estamos indo bem? É o caso do guia? Não é o caso do guia? Qual a sua opinião a respeito?
Thank you, and thank you for the deeply fascinating question. Before I get to my answer, I need to start with the same disclaimer as Christian, which is that the following remarks simply reflect my own views and should not be taken as any indication of the FTC's, let alone any of its individual commissioners. So I think at a very high level, there has been, I think, a general consistency of analysis of vertical mergers, which is that the goal is to be granular and fact-based and to get the context correct. And certainly, that is why we continue to look closely at the documents that we obtain from parties, why we interview closely different practitioners in the area, competitors, customers, so as to build out our understanding of how competition in the potentially affected industries takes place. Now, as Dan has alluded to, vertical transactions can involve a host of compounding and offsetting effects that can vary in their intensities depending on many of these different dimensions of the way markets function, depending on how prices are set. Are they linear? Are they non-linear? Are contracts bargained over? Are they posted prices? These factors can matter a great deal in vertical merger analysis. And for that reason, while I completely agree with Dan's overall take that that VGUPI represents an advancement on kind of earlier methods, I also completely agree with his take that it is not a sufficient standalone tool for the analysis of your average vertical transaction. Certainly, I think the fact that it drops out of kind of the underlying economics is a substantial advancement. I think that can clarify and provide some intuition for the potential factors being involved. does it seem like the transaction may give rise to an incentive to raise rivals' costs, perhaps through input foreclosure? Does it seem like there might be very large elimination of double marginalization effects? I think VGUPI can kind of provide a 30,000-foot level of those effects. But if it looks like both may be in play, you really do need to think about exploring the robustness of the VGUPI conclusions with a more rich, fully specified economic model in order to make sure that the conclusions you might be drawing are robust. And there's an emerging simulation-based literature that makes this point. So, for example, there's a working paper by Gopal Dasvarma and I believe Martin Di Stefano of Charles Rivers Associates that makes the point that in an equilibrium context, you can find that either VGUPI predicts bad mergers when in fact they're good, or good mergers when in fact they are anti-competitive. So again, it may be a useful screen, but it is one that definitely needs to be supplemented by kind of deep thinking and further analysis and that is tailored explicitly to the relevant market context. Now I think there is movement in these dimensions, but again, because of the extensive variability of the details of vertical transactions, it does mean that the ultimate analysis often has to be bespoke, individualized to fit a particular transaction. Now that is a tackleable problem, both for enforcers and for private parties, but it is going to mean that we cannot follow such a simple algorithm, perhaps, in analyzing these types of transactions. And then my final point would be, even when both sides of litigation or of a given argument about the potential effects of a merger agree on the framework, I think it's going to be very common that there is deep disagreement about what that framework is telling us about the effects of the overall transaction. A lot of the implications of the model will depend on the particular inputs that you are feeding into it, right? And I think, again, the AT&T case is one potential example of that, where there was intense disagreement, partially related to the relevance of the bargaining model used, but also about the particular parameters that the DOJ's expert was using in that modeling context. So I think, in general, there is going to be a deep role for economists to play in the assessment of vertical mergers. And as always in antitrust cases, the conclusions we draw from these models are going to have to be wedded back to the facts on the ground and to business realities. Thank you.
Voltando rapidamente aqui para o Dan, ainda a respeito de concentrações verticais, né? Ontem nós discutimos no painel de relações alguns aspectos das fusões verticais e um dos pontos que se tocou rapidamente ontem, e eu gostaria que você comentasse, indo diretamente para a questão das contratações não lineares, existe esse argumento ou essa discussão a respeito das contratações não lineares eliminarem diversos efeitos potenciais de marginalização nas fusões verticais, né? Eu queria saber se efetivamente você concorda com isso e, nesse aspecto, restaria a ser analisada apenas a questão de fechamento de mercado nas fusões verticais, ou seja, a marginalização bilateral não seria um issue, preços não seriam um issue, apenas efetivamente fechamento de mercado?
Yeah, so this is a big topic that we touched on in the session yesterday. Let me make 4 points about this issue. Does nonlinear contracting, eliminate EDM benefits, and does it change the way we should do our analysis? Most antitrust is built on simple models that, at least on the economic side, that assume linear per unit pricing. Right? Almost all of our models of horizontal mergers make this assumption. There are some exceptions that I'll mention in a minute, but under linear pricing, if firms have market power, there are EDM effects. Okay, so the standard framework that we use has, EDM when firms have market power, when there's a vertical merger. Okay. Second, if there is nonlinear pricing, and nonlinear pricing, what does that mean? It can take a variety of forms. You charge a flat fee plus a per unit price. If you negotiate the quantity, okay, and then a price to divide the surplus, or the gains, that's a nonlinear price, okay, because it's not a simple price per unit depending on how many you use, okay? It's a price for this many units, an explicit price. There's a whole range of different nonlinear contracts that we see, and we see them in intermediate good markets a lot. But EDM effects do not automatically disappear, as some seem to assume, when there's nonlinear pricing. An upstream firm with market power that contracts with several downstream firms that have some degree of market power doesn't want to dissipate all of the rents available by negotiating a bilaterally efficient contract with each of the downstream firms. Okay, a contract that effectively transfers the product at cost, okay, and causes competition among the downstream firms to dissipate all of the rents. The upstream firm would rather commit to some kind of contract that softens competition among the downstream firms so that it can collect some share of the benefits of that softer competition. And so, there's a literature that I participated in that goes back over 25 years now that looks at situations where nonlinear pricing does and does not eliminate double marginalization. And it's a complicated set of conditions. But the point is that nonlinear contracting does not automatically eliminate double marginalization. So it doesn't automatically eliminate EDM effects. It's a long discussion. A third point I would make is because EDM effects disappear only in one special case in this literature, one special case with certain assumptions about the information structure, what competitors think about what their rivals' contracts look like, and so on. We're not in a position to argue that EDM or EDM-like effects are missing in action. And I did say yesterday that when we use the elimination of double marginalization as a benefit, that's actually a metaphor, I think, not just for price effects, which we tend to focus on in our analysis in antitrust, but also for any kinds of benefits that arise from aligning the incentives of complementary producers, including investment incentives. And if there's any investments that are made by complementary producers that benefit the other complement that are not contracted for in advance, there's a benefit that is the investment analog of EDM. And the fourth point I would make is, suppose it were the case that nonlinear contracting, sophisticated contracting, eliminates EDM benefits. What does this mean for horizontal mergers? I'd recommend a paper in 2005 in the RAND Journal that actually analyzes horizontal mergers under this assumption. Contact me and I'll send it to you. That paper predicts that horizontal mergers by large, powerful firms increase welfare unless the firm is not allowed to bundle. Okay, if the firm can bundle, horizontal mergers that happen are going to increase welfare if there's perfect nonlinear pricing. It really has a dramatic impact on our analysis of horizontal mergers if there's nonlinear contracting, as there is in a lot of upstream markets where a lot of mergers that we analyze occur. Okay, so there's a whole overlapping complex array of approaches to antitrust that would be affected if you believed that EDM effects disappear because you have nonlinear contracts in input markets. I'm not ready to cede the floor to those who think that EDM goes away from nonlinear contracting. And I'm not ready to push the implications that I just described for the impact of horizontal mergers when there's nonlinear contracting. But I think this exposes the need to be really careful in attempting to craft vertical merger guidelines, given the complexities that arise in vertical contracting. One final point I'll make is the suggestion was made that maybe this means that that we should only focus on dynamic foreclosure effects. If there really are no EDM effects, there's still input foreclosure effects that are not dynamic in nature. If there is no EDM effect, you still have the partial foreclosure impact of having an incentive to raise price to unintegrated downstream firms. I'm thinking about input foreclosure. So in a static world where you're not worried about knocking somebody out of the market, if you really did believe that there were no EDM effects, you would have anti-competitive vertical effects. And I would never deny that. The issue is it really true that there are not EDM-like effects? Yeah, thank you.
Muito obrigado, Dan. Passando agora para o tópico de remédios, na Sul, gostaríamos de perguntar quais seriam, na sua opinião, os pontos de atenção tanto no desenho de remédios como na implementação de remédios.
Bom dia, Leonor, Lauro e Francesco, obrigado pelo convite. Não falo português, pero I'll continue in English. I think, as you all know, that remedies can be put into a number of situations. The first one is on horizontal mergers, and as you may have seen, there's been like the Holcim-Lafarge merger, where there was a number of remedies. Vertical mergers, where, for example, the Broadcom-Brocade case, which was a behavioral remedy case, and also remedies are sometimes imposed to close some market investigations, and also in state aid cases. And more recently also we have seen interim measures in the anticipated mergers or in the antitrust cases. I think in the last couple of years we've seen a number of more behavioral remedies being imposed all across the world. China used to be the one which imposed more behavioral remedies. But now we have seen a number of authorities around the world, like PCC in Philippines, Singapore, even European Commission, and in the US. And our role is to monitor the remedies at the eyes and ears of the competition authorities and to deal with any disputes in relation which may arise in those remedies. If I may touch first on structural remedies, this is where you may be divesting a whole business, or you may be divesting just a product. I think the remedies should be designed in a way which will make the implementation quite easy, and also have a sort of minimum disruption on their business which is being retained. I think main issues we've been seeing in the last few years is about the divestment package which is offered, and sometimes these are not being attractive to potential purchasers. And you may have seen also in the news about the Disney Fox, where I think they find it difficult to find buyers. And in some of the cases we've worked on, the purchasers don't find the divestment package attractive. They want something a bit more about this divestment. And sometimes also you need to provide a number of key personnel. So you need to decide whether you will offer some of your key personnel with that package. And also, when it comes to divestment, it may not only just be a business, it could be just a product. And sometimes when you divest that product, you're only divesting the intellectual property. And in order to make it attractive, you should provide some technical training and skills to the buyer so that they can take up production going forward. But overall, I think in terms of, I would say my tip for designing of structural and behavioral remedies is to make sure to get people involved at a very early stage, because they will be the one who will take ownership of implementing this through an implementation plan. We've worked on cases where there are people who are dealing with us and responsible to deliver, to comply with these remedies, but they are a bit lost, and they said, well, we didn't know that was required as part of their divestment remedies, and it's only now that it's been agreed with the Commission authorities, they get to know it. And it can be quite frustrating. So I think it's, if you can get your client to get the right people involved right at the early stage, it's very useful. And also I think when it comes to divestment remedies, there is a lot of stress among employees, and employees sometimes think that because the business is being divested, they will lose the jobs. Some of them will get to the trade unions and make a big noise about it. And I think having proper communication early on in place that this business is being sold to a buyer, which will keep the business going viable, and also will be a buyer approved by the competition authority and by the monitoring trustee, and I think that will give a bit more confidence to the employees. In terms of reporting, as you may know that when you negotiate the remedies, you will have to put into the commitments how often the monitoring trustee has to report to the competition authorities. And this can be monthly in the structural remedies, but in behavioral remedy, it can be negotiated. So you can ask for like a 6-monthly reporting or an annual reporting. And we are working on a case where we have different reporting frequencies in different number of jurisdictions. For example, on the brocade case, we don't have any reporting to the European Commission, but for the FTC, we report every 6 months, and for summer in China, we report once a year. And I think my final tip on remedies design would be about the length of those remedies. And I think when it comes to behavioral remedies, those are usually quite long, and but you can also include a clause in those commitments that this will be can be revisited if anything changes in the market. Sometimes, you know, like if the merged entity now have a market share of, say, less than 35% because there's been new entrant in the market, you can go back to the competition authority and ask them to revisit and maybe get the commitments revoked.
Okay. Já ia falar inglês de novo. Nazu, dentro da sua experiência como trustee em vários países, como é que você vê, ou podia nos contar aí um pouco, na sua experiência, qual é a diferença na forma de nomeação de trustees? Quer dizer, o que você sentiu de diferença entre Brasil, China, Estados Unidos e em relação à Europa também? Quer dizer, como é que é esse processo de nomeação? Certas dificuldades, certas facilidades, alguma reclamação, alguma angústia sua sobre como atuar nesses países?
I think the appointment process is quite common across the world. It's the parties who put forward the candidates. They will select the candidates based on their experience as the trustee, their skill sets, industry experience. And some of the competition authorities will require just one candidate for them to consider and approve that. But China usually asks for, well, not usually, but it's part of their requirements is they ask for 3 candidates. And the parties then have to find 3 candidates, and those 3 candidates will then be interviewed by their the summer, like a panel of interview. And these interviews usually last only 20 minutes. So 15 minutes for you to present your case and 5 minutes for your questions. So we usually fly over 11 hours to have a 20 minutes interview. In terms of CAGE, and I think when it comes to global cases, CAGE will probably follow the same process which has been agreed with the European Commission or the FTC. when we worked with on the Cineverse Mac case, which was in 2013, which was a European Commission and CAGE case. CAGE followed what the European Commission has appointed, but we still had to go through the vetting process. We had a vetting conference call with the CAGE case team. I think I can't think of any other difference. It depends on in European Commission. On some cases, they will ask just for one candidate. In some cases, they will ask for 2 or 3. It depends on the case, and if it's a joint venture, they may ask for each joint venture party to provide to submit a candidate from each side. And in the US, when we were appointed by the FTC, we had a joint vetting call with the FTC and the European Commission. And on that case, the FTC took the lead because most of the remedies were in the US rather than in the European Commission.
Muito obrigado, Nassu. Passando agora para o contexto de ações indenizatórias em casos de cartel, de private litigation, Rick, uma pergunta bem direta e bem concreta, especificamente com relação ao Brasil, pela sua experiência, né? Uma ação relacionada a uma compra e venda feita no Brasil, ela pode ser baseada no direito antitruste da União Europeia, quando as constatações factuais da União Europeia, elas envolvem a existência, né, ou a investigação de um cartel mundial ou de uma conspiração global?
Yeah, I will try to answer that question concisely, although I need a little time, I'm afraid.
Concisely, please.
Yeah, of course. EU competition law relates to conduct that may affect trade between member states and that restricts competition within the internal market. So that already reveals that a direct nexus or a direct connection with the EU is in some way required. So the question is a bit broader. Does EU competition law apply to conduct or agreements concluded outside the EU or concluded between non-EU based undertakings, or does it relate to conduct in relation to sales that have been made outside the EU? And the European courts have made some clarifications on this issue. And I think the first clarification that can be identified is in the so-called wood pulp judgment, which was on a cartel case where non-EU entities formed a cartel outside the EU, but they implemented that cartel in the EU. So they sold directly the cartelized products to purchasers within the EU. So those direct sales were considered to be the implementation, the actual implementation of the cartel, and as a result of that, it was, or the Court of Justice ruled that this fell within the scope of EU competition law and within the scope of the EC decision. Then, a few years later, we had another case, but that was a merger case, which was dealt with by the General Court. And there the question was whether the concentration had effects in the community, at the internal market. And the General Court ruled that as long as it is foreseeable that a merger has immediate and substantial effects in the community, then it's supposed to fall within the scope of EU competition law. But that actually raised another question. Does this qualified effects test, what they call it, does that only relate to merger decisions and merger control, or also to anti-competitive conduct? And that question was answered in the Intel case, but only in 2017, so almost 18 years later. And that was an abuse of dominance case, where the Court of Justice of the EU ruled that the qualified effects test pursues the same objective, namely the preventing of conduct which, while not adopted within the EU, has anti-competitive effects liable to have an impact on the EU market. So it was finally clarified that both tests, so the implementation test and the qualified effects tests, are applicable to anti-competitive conduct. So the question is how to establish that. And in Intel, the court, I think, went to the next step, and it said that you should assess whether a certain type of conduct is part of an overall strategy, and whether that conduct was capable or had the intention and actual operation of the cartel, whether that was capable of producing an immediate effect in the EU. So in order to summarize, if the claim is based on conduct that falls within the scope of EU competition law, which conduct so either has been implemented in the EU or had foreseeable immediate and substantial effects in the EEA and caused harm to the claimant, in that case a damages claim can be directly based on an European Commission decision, and otherwise it cannot. And it follows from those judgments that direct sales within the EU will have a direct effect on the internal market. And the same goes for direct sales, not of the cartelized product, but the direct sales within the EEA, which relate to transformed products, so products in which the cartelized products has been incorporated. Also, those sales will fall within the scope of EU law, and claims in relation to those sales can be based on the EC decision. But the remaining question is, what about sales outside the EU? And I think it's too early to finally answer that question. However, if you look at the Commission decisions themselves, and also some other statements made by the Commission or by representatives of the Commission, you could say that the Commission does not want to include those types of sales within its jurisdiction and within the scope of EU competition law. If you look, for example, in some of the EC decisions, I have here an example of the CRT decision. The Commission explicitly states that insofar as the activities of the cartel related to sales in countries that are not member states or contracting parties to the EEA agreement, they lie outside the scope of this decision. And the same goes for a recent hearing on the power cables case before the European courts in Luxembourg, where the lawyer for the Commission explicitly stated that neither the regulator's statement of objections nor its decision concerned activities related to sales outside Europe. So if a Brazilian claimant would like to bring a claim that relates to sales and purchases that were made in Brazil, I think the chance is currently low that it will be accepted that those sales fall within the scope of an EC decision and that you can base your claim on an EC decision. But that might be different if the claim does not relate to sales outside the EU, but to direct sales or indirect sales within the European market. I think then it's, the chance is very high that you can rely with your claim on the EC decision and on EC competition law.
Obrigado, Rick. É bem interessante esse tema, tem sido discutido recentemente. A gente vê algumas notícias de empresas brasileiras, cooperativas, procurando ações na Europa, especificamente em Londres. Então é um tema extremamente interessante para nós. E eu queria ouvir do Robert quais são a sua visão a respeito desse tema e especificamente como é a aplicação extraterritorial da legislação americana a esse respeito. Por favor.
For purposes of U.S. law, the analysis would be much the same. If a Brazilian purchaser was suing for purchases made in Brazil, the U.S. law would almost certainly not apply. If a Brazil company was suing in the U.S. for purchases that were made there, it's likely that U.S. law would apply, but further analysis would be needed to focus on where the conduct occurred. Domestic U.S. conduct, there'd be no issue. Domestic U.S. conduct, domestic purchases, doesn't matter who the plaintiff is, they've got a claim under U.S. law. But for conduct that occurs outside the U.S., a separate analysis is required under the FTAIA, the Foreign Trade Antitrust Improvements Act. And the first inquiry is whether import commerce is involved, and if not, the question is whether there's a direct, substantial, and reasonably foreseeable effect in the U.S. When that's the case, and the claim that's made by the foreign purchaser or domestic purchaser arises out of that impact, U.S. law would apply. But I want to point out some developments underway regarding the FTAIA. In a series of high-tech component cases, issues were raised about situations that involve foreign price fixing and incorporation of the price-fixed good into a finished product that is purchased in the U.S. There have been somewhat mixed results in those cases, but the tendency in the more recent cases has been to uphold the application of U.S. law. One of the cases in which that took place is the capacitors class action. And the capacitors case is headed for trial early in 2020 before Judge James Donato in San Francisco. It's possible that out of the judgment in the capacitors case, a review of the FTAIA issues will be carried out on appeal. There are a variety of issues under the FTAIA that will have to be decided sooner or later by the Supreme Court. A few years ago, the thought was that the LCD case would provide the vehicle for that, but the Supreme Court turned down the multiple petitions for certiorari that were filed in LCD. Perhaps capacitors will generate something of interest in the Court of Appeals for the Ninth Circuit, and maybe that case will get to the Supreme Court. But sooner or later, this question involving price fixing of intermediate products or components will have to be addressed.
Muito obrigado, Robert. Nathan, passando agora rapidamente para o tópico de investigações, você poderia comentar um pouco como você vê o papel da economia e dos economistas e como eles contribuem para o enforcement concorrencial? Especificamente, que tipo de análise tem mais impacto e se essa avaliação muda de acordo com o estágio ou até a própria natureza da investigação?
Thank you, and I'll try and be brief. And I'll start with a sweepingly hubristic comment as an economist in a room full of attorneys, which is that I think at a very high level, antitrust is economics, right? Economics is the source of our intuition about the types of conduct or events that might be problematic, and it's also informative about the types of solutions that we should be looking for those problems. So I think economics, at a very high level, contributes enormously to antitrust. Now, if we drill down to a more granular investigation level, I still see the role of economists as quite important, perhaps unsurprisingly given my background. And I think, again, working in tandem with our colleagues, the focus remains the same, identifying potential problems and focusing on what we would need to identify in order to understand just exactly how large those problems may be. And it's there that I think our training in formal analysis and statistical analysis can be useful in providing some degree of quantification, perhaps probabilistically, about what the net impact of potentially offsetting effects may be. Now, I think over the course of an investigation, that emphasis on identifying what's important and measurement remains the same. But I think what I find interesting as a practitioner is how what I emphasize and how I talk about these things changes depending on the audience I may be interacting with. So initially, when maybe I am trying to discuss the operations of a market, I will be interacting with highly informed counsel inside the FTC or from the outside economists deeply ingrained and trained in the modeling techniques I might explore. And so that discussion can be very technical, heavily reliant on perhaps even mathematical equations in our conversations. Now, as the investigation transitions, now that deeply technical background remains, but how it gets talked about has to change, of course, because though Dan and I might be most comfortable talking about first-order conditions, parameters, lapsing into an emphasis on Greek characters, there is a good chance that portions of our audience of an increasingly large size will not find that particularly edifying. And as a result, we need to think about how do we translate the intuition that we see in mathematics and equations to a world that doesn't necessarily find those equations and mathematics quite so intuitive and obviously relevant. And so I think that is one of the great interests for me in being a practitioner of antitrust, is wedding what I think is the power and elegance of formal economics to the real world. And it's also one of the biggest challenges. Thank you.
Obrigado, Nathan. Antes de eu passar para a próxima pergunta, só informar aqui aos panelistas que nós estamos sendo pressionados aqui pela chefia geral para reduzir o tempo, para a gente ir caminhando para o final. Então, nós ainda temos 33 perguntas, mas eu vou fazer só 2. Vamos ter que pular e fazer só 2. Então, desculpem aí a correria do tempo, mas é necessário, senão depois eu tomo bronca. Então, eu queria perguntar então, para o Benjamin, na experiência dele, uma vez que as comunicações hoje, mídias sociais, WhatsApp, Google Message, etc., tem acontecido, na realidade, um desenvolvimento desse tipo de comunicação, até que ponto esse tipo de comunicação facilita a realização das condutas anticompetitivas e até que ponto essa questão de sigilo desse tipo de comunicação afeta as investigações na sua experiência? Por favor.
So I think the changing ways in which we're communicating are going to pose a real challenge for enforcers on the cartel side. It was once the case that when I started at DOJ, my more senior colleagues would tell me about cases involving dozens of boxes of hard copy documents. And that's how they proved their case along with witness testimony. Then the cases sort of moved into email-intensive cases, and then from there, more recently, to cases involving Bloomberg chats and other kinds of rapid-fire communications. I think the next wave, the thing to consider is what happens when people are communicating via methods that are instantaneously going to disappear, right? One thing that has struck me spending some time in Brazil is that WhatsApp is really a mode of communication for business people to talk, right? Not just personal communications, not just I will meet you at 5 p.m., but actually business is conducted, right? What happens when all business is conducted on WhatsApp and other kinds of communications that do not leave as much of a trail? So I think the enforcers in all countries are going to have to start thinking about this, because my sense is if cartels are furthered through communications, it's possible they're furthered through these kinds of communications, as opposed to things making a more lasting stamp. I think it's going to be probably even more important than it was before to have a cooperating witness and early in an investigation who will lay out the contours of a conspiracy, because it's going to be more difficult than maybe it once was to have a large documentary trail that you can rely on.
Muito obrigado, Ben. Passando a última pergunta aqui sobre cooperação internacional para o Christian. É sabido por todos nós, é uma discussão que existe há muito tempo, a questão da importância que as próprias autoridades de todos os países dão para o engajamento e para a cooperação internacional. Aí acho que a nossa pergunta seria, você pode comentar um pouco sobre o status da cooperação internacional e se você teria alguma recomendação concreta nessa seara?
Muito obrigado pela pergunta, Francisco. When it comes to this particular question, international cooperation, what is the status of international cooperation? What is the status? What is happening in the area of international competition cooperation? I think the quick answer is a lot. When you actually look around today, you have over 130 agencies actively enforcing competition laws. Obviously, globally, that means too much more antitrust activity, and we see that every single day. On the other hand, you also see more interconnectedness when it comes to the global commerce. Simply, there are more global or more international mergers and acquisitions taking place every day. There is also more cross-border conduct. When it comes to these two particular elements, and then they go hand in hand, you really see that based on more cross-border activity, with having more agencies enforcing actively competition laws, it obviously will lead to not only more activities, but more opportunities on the one hand, and more challenges as well when it comes to cooperation. That is true both for competition and council representing them, and the competition agencies actively enforcing competition laws. What is the result of that? I think what we all can see is today in the antitrust practice is truly an international practice. You just cannot really be a domestic practitioner anymore. It's often not only international, but it's a global practice. And many of you work on many deals and many cases that might have implications in other jurisdictions and countries as well. When it comes to cooperation, we see a lot happening multilaterally, at the multilateral fora. There are a number of organizations, both worldwide and at the regional level, that actively focus on competition enforcement and policy issues, from the ICN, the International Competition Network, to the OECD, Competition Committee, UNCTAD, and others. And on that note, I would also just like to mention that it was truly gratifying to see how Brazil, following last November's succession review within the OECD Competition Committee, earlier this year became an associate member of the OECD Competition Committee. So on that note, parabéns, CAGI. It really is an excellent achievement. Also, when it comes to, in addition to the multilateral coordination and cooperation, you see there is simply much more happening at the bilateral basis these days. For example, when it comes to case cooperation, enforcement cooperation, a few years ago, perhaps it was unthinkable that there would be merger cases in which there is more than 10 or 15 agencies working together. This now happens, I would say, surprisingly common, surprisingly frequently. Earlier this year and last year as well, for example, the US FTC, the agency where I work in, worked on, for example, Praxair-Linde, a merger many of you might be familiar with, together with CAGI and the European Commission and 8 other competition agencies from all over the world. When it comes to how much cooperation we have, it actually has been increasing significantly over the last few years. Just the US FTC, for example, last year, worked on 43 cases with 19 other jurisdictions, competition agencies. And I would like to thank my colleagues, from CAGI for having provided me those numbers. But when it comes to CAGI as well, you see a significant increase how actually CAGI has been working with other agencies all over the world. And with thanks to Noemi and others in CAGI's international office, I can tell you over the last 3 years, for example, CAGI worked on 28 merger matters with 15 agencies all over the world. That is an ever-increasing number, and that's the same pattern that you see happening with other competition agencies all over the world as well. In addition to enforcement cooperation, working on cases under parallel review, you also see there is simply more happening in the policy area as well. There's more policy cooperation between agencies, not necessarily focusing on individual cases, but perhaps broader competition issues like how this particular agency reviews or looks at, say, issues when it comes to pharmaceutical sector or generic pharmaceuticals or merger remedies that we've also heard about. So we now generally talk more with other agencies as well, and that's a phenomenon that you see all over the world about particular policy issues too. That can be horizontal mergers, that can be conglomerate issues, and any of those. And these days, of course, not a surprise, as having talked about digital issues is a big chunk of the discussions that took place over the last couple of days. There's more discussion happening in that space as well, digital issues and the concerns and the potential challenges in the digital area. For example, the BRICS report also called for more cooperation among competition agencies focusing on those issues. In addition to that, there is also more exchange of information actually through sending people, resident advisors, or working in other agencies as well. I, from that perspective, also feel fortunate that I had an opportunity earlier this year to work for a few months at CAGI. There's simply more coordination going among agencies in that regard as well, that perhaps advisors or folks from one agency to another go and spend some time working hand in hand with other competition officials. And just touching up on one last and very important point, I would like to highlight the very important role of council that actually can promote international cooperation in this space. I think in particular in the merger review area, when incentives really are to get the deal done as quickly as possible, we really see that, for example, when it comes to waivers of confidentiality, they are really commonplace now, and they're really routine when it comes to international mergers, that council and companies actually do provide those for the agencies. When it comes to main impediments, main challenges with regard to cooperation, often is the difficulty of exchanging information, which can be significantly promoted and enabled by council and the companies if they provide the agencies with those opportunities, which on the one hand will speed up the process, but very importantly on the other hand, it actually not only will speed up the process, which is the final objective of both council and the companies, for example, merging or doing an acquisition, but also it will lead to the fact that hopefully agencies will be able to avoid inconsistent outcomes. They will be able to coordinate their analysis. And when we talk about remedies, for example, you see that they will be complementary, or they most importantly, at least will not be incompatible. Thank you very much.
Muito obrigado, Christian. Acho que da nossa parte, gostaríamos de fazer um agradecimento especial para todos os nossos convidados, todos os panelistas que tomaram um tempo importante para a preparação desse painel, nos nossos calls, nas nossas reuniões. Muito obrigado. O Lauro fez questão de que eu informasse a todos que o coffee será servido lá fora, mas não aqui dentro. Eu queria que o Lauro fizesse esse comunicado, mas ele delegou para mim. Muito obrigado da minha parte a todos.
Na realidade, o que eu pedi para informar é que não teremos intervalo. Como ele não teve coragem, comunico a vocês que não teremos intervalo. Cafezinho só depois do painel final, por favor. E gostaria de novo agradecer aos panelistas e informar a todos vocês que eu enviarei as 31 perguntas restantes por escrito para vocês nos responderem. Muito obrigado a todos.